Hi, today I'm here with Cesar Gavidia. And Cesar, I know you recently just resolved a case that you've been working on for quite some time, and it was a great outcome. So tell us what was challenging about this particular case and how you think you were able to achieve what you did with the case.
This particular case was against Prudential, Greg. We handled an administrative appeal with them, which, as you know, is one of those steps in the ERISA process that you have to go through before you could ever file any sort of lawsuit against them when they've denied your benefits. And our client was an IT specialist, so he worked on computers, networking, installing software, repairing computers for his employer. And he was diagnosed with cancer in his ear, which basically threw off his equilibrium, caused, obviously headaches, dizziness, weakness, fatigue, all of this cascade of symptoms and problems that he ended up suffering as a result. And he had to go on leave from his job and ended up having to file long-term disability with Prudential. Now, as we've seen, which is classically the case, the Prudential approved the benefits for about 10 months and then ended up cutting him off. And the reason they cut him off was they had claimed to send him his case for a review, which is often done by one of their quote-unquote clinical consultants or medical consultants. And I don't know if you've noticed, but usually in their denial letters, they don't even describe what this clinical consultant is. Is it a nurse? Is it a doctor? They don't really give you much information concerning their qualifications. They just say, oh, we had your case reviewed by a clinical consultant. So part of the challenge is discovering who the heck this person is.
Right.
What kind of qualifications do they have to basically trump the opinions of your doctors? So we went through the administrative file, got all this information, all this evidence concerning who this medical consultant was, what they did in his case file, and really what we discovered is when they applied the usual occupation standard, in his case an IT specialist, to the restrictions and limitations he was compared to, it was completely off. So they described his job as being a light-duty job, and they focus in on, well, what are the physical demands of a light-duty job? Oh, can you lift a box that's 10 pounds or 15 pounds? Can you stand or walk for more than 5 or 10 minutes? And if you can do that, oh, we think you can do your job, okay, and you're not disabled. And after 10 months where they had paid him and they clearly had found that he was disabled and nothing had changed, he was going through cancer treatment, he was going through basically trying to recover so that he could potentially go back and do something at some point, they just cut his benefits off without anything at all changing. So we addressed all of this in the administrative appeal, and probably within 3 or 4 weeks they overturned the decision and advised us that he was going to be awarded his back benefits.
What type of clinical reviewer did they rely upon to say that he could go back to work?
So what they ended up doing when they described who this person was, basically a nurse consultant. Nurse consultant, is the one who looked through the medical records and determined that based on what they saw there were no restrictions and limitations, or the restrictions and limitations, as they described them, weren't supported by the medical evidence, which was really inconsistent with what they'd already had determined earlier in the case.
Right. How do they get away with that? I mean, how do they have a nurse who went to school for maybe even just got an AA degree, possibly had a college degree and then 2 years of nursing or something like that, versus a doctor who was an oncologist and plus his other ENT doctor that he had, who have gone to school for 12 years, plus residency and everything else, plus they treated the patient, they didn't even examine the patient. How do they just do this quick paper review and say, oh, sorry, you're not entitled to benefits?
Look, I'd have to say it's probably because they feel they can get away with it. It often comes down to these insurance companies knowing that if the case is governed by ERISA, that all they have to show is some reasonable basis. And what's that entry-level threshold for a reasonable basis? Just find somebody with a medical qualification to do a case review file rather inexpensively. Usually a nurse is in-house. They don't charge very much, if anything at all. They might be on the payroll. And they just go through the medical records. This is what they do day in and day out. And then they issue these opinions that say, well, we don't see anything here. And it's really completely arbitrarily just saying, look, from what I have read here, I don't see any support.
The problem is there's no punishment, there's no
Right.
consequences for the insurance company in ERISA, there's no provision to pay attorney's fees when the claimant has to go out and hire an attorney. and there's really no sanctions for the disability insurance company until such time that you file a lawsuit. But as you know, you can't file a lawsuit under ERISA until you exhaust all of your appeals. So thankfully, in this case, you were able to do a great job and win the appeal for this claimant, and you continue to monitor his claim and make sure he gets paid every month, because just because you won this appeal doesn't mean that Prudential is not going to try to mess with him.
No, and one important thing is that we're still in the own occupation period. So, you know, that's usually in most policies is a period of 24 months. In some policies, it's even shorter. It might be a 12-month period. In this case, with Prudential, it's 24 months. So what's really important about this is that at some point, they're going to do another medical review, another claim review, and that's going to come after that, well, probably right before that 24-month period is exhausted, to determine if he can perform any gainful occupation.
Right. So then you'll get into, we didn't think he could do light duty. Now we think he could do sedentary duty,
Right.
which is basically the ability to sit for more than 4 hours a day, along with a variety of other things. So I know you're gearing up for that to protect him, and hopefully that transition will go smooth so that he'll continue to get paid into what's known as the any occupation period. So if you have a claim with Prudential or any other long-term disability insurance company, feel free to give any of our lawyers a phone call. We always offer a free initial consultation, and we'll let you know right away whether or not we can assist you.